Okay, now that it's 1 o'clock, let's go ahead and reconvene for our last panel of this class action conference. And thanks once again to all of our speakers who so graciously gave of their time for this conference. And thanks also to all of you who have been participating in this conference. We've covered a ton of material over the past 3 days. So hopefully everyone has found that material both informative but also enjoyable. So let me get started by introducing my colleague here at BRG, Brad Cornell, who is a managing director and is a financial economist and really one of the leading experts on valuation. In addition to being my colleague here at BRG, Professor Cornell, for over 40 years, has taught courses on, written books on, and scholarly papers on in a wide variety of matters involving valuation, damages, and securities. Professor Cornell is an emeritus professor at UCLA, and he is developing a new course specifically related to today's panel, and that new course is entitled Energy, Climate Change, and Finance. Over the course of his career, Professor Cornell has published more than 125 articles on a wide variety of topics in applied finance, investments, and valuation. So with that introduction, let me turn the microphone over to Brad to introduce his panel and the rest of today's speakers. Thanks a lot.
Thank you, Jeff. And I should add that I did found a climate change practice at BRG, and hopefully that will be of some interest to people. I think this last panel, and we appreciate you hanging in there for it, is a little bit unique because it's an area that's definitely developing. Nobel Prize winning economist Bill Nordhaus has called climate change the mother of all externalities. And I think that goes without saying. The problem for the law, and that we'll address here, is it too big a problem? Is it something that is so immense that it has to be handled at the legislative level or even at the international level? And Jeff, I think we have a polling question that we wanted to run before I introduced the panel and we got underway. Is that available? Well.
Brad, let me see if Jen has access to that polling question. There it is.
Well, I find these results to be really interesting. I would have assumed they would have been about the reverse from what I'm seeing on the screen. And so I think our panelists are really going to have a good time with this, and hopefully you will too. So let me introduce the panel and get out of the way. We have three great people today. The first is Michael Gerrard. He's a professor at the Columbia Law School, where he teaches courses on environmental and energy law. He also directs the Sabin Center for Climate Change Law at Columbia. He's a member and former chair of the faculty of Columbia's Earth Institute. Before moving to Columbia in 2009, he practiced environmental law in New York City for 30 years, most recently as a partner in charge of the New York office of Arnold and Porter. He has written or edited 14 books on environmental law. Second, we have Katie Beran. She's a partner in Hausfeld's Philadelphia office, where she focuses on complex litigation on behalf of plaintiffs in the areas of environmental, antitrust, civil, and human rights law. She also maintains an active pro bono practice, which includes environmental justice matters and climate change impact litigation. She's been named an energy and environmental trailblazer by the National Law Journal, and she was recently selected as an On the Rise Top 40 Young Lawyer by the American Bar Association. Thank you, Katie. And our third participant is Gay Sigel. She's a partner at Jenner and Block and co-chair of the firm's Climate and Clean Technology Law Practice and of the firm's Environmental and Workplace Health and Safety Law Practice. She's been practicing in the area for more than 30 years and has been involved in some of the most exciting environmental litigation that has occurred over that period. She and her partners regularly represent a wide variety of energy companies. However, she also represents local governments and has been an active pro bono, has an active pro bono practice. So that's the group. It's a great group. And as the panel director, I think it's my job now to get out of the way. We'll start with Michael Gerrard, looking at the current landscape of climate change litigation and perhaps commenting on the results of our poll. Michael, take it away.
Thank you very much. Thank you for having me, and I'm going to try to share my screen here. Give me a second. Can you see that?
Not yet.
Not yet, eh? Let me try that again.
Ah, great. It's coming up.
Okay, there we go. So we maintain at the Sabin Center, we maintain a database of all of the climate change litigation happening around the world on our website. And of these cases, we found a total of 1,452 cases as of the end of last year. The U.S. is by far the champion. We have 1,134 of the 1,400 some in 30 countries. In the U.S., the largest volume of cases by far is about statutes under the National Environmental Policy Act and its state equivalents under the Clean Air Act and various other laws. In the last 3.5 years, there's been a large volume of litigation challenging the efforts by the Trump administration to roll back environmental regulations, and the administration has accumulated a very poor record in that. A very large number of these actions have been defeated in court, largely because of procedural problems under the Administrative Procedure Act or the National Environmental Policy Act. We have the famous Juliana case, but I believe that Katie is going to talk about that, so I will leave that to her. In a conference on class actions, I think one very important case to look at was American Electric Power versus Connecticut, where Connecticut and several other states sought an injunction against half a dozen power companies to require them to lower their greenhouse gas emissions. This was based primarily on a federal common law of nuisance theory. The Supreme Court, in a decision by the late Justice Ginsburg, unanimously said, no, this was displaced by the Clean Air Act. The Clean Air Act gave EPA the authority to regulate greenhouse gases. There is no longer a room for the federal common law to regulate greenhouse gases. This lawsuit was seeking an injunction. There was another lawsuit going on around the same time seeking money damages brought by this village in Alaska that needed to relocate because climate change was causing the ice around it to melt and causing all kinds of problems. This case was dismissed by the Ninth Circuit based on the American Electric Power case, based on the idea that it was the federal common law of nuisance existed to fill in gaps, and there was not a gap in federal law because we have the Clean Air Act. The Supreme Court in the American Electric Power case explicitly left open the question of whether the state common law might be applicable. And beginning in 2017, we had a whole flurry of these lawsuits brought. There are now, I guess, 17 of these lawsuits that have been brought, all against various fossil fuel companies, brought primarily by counties and cities and a couple of states and one fishermen's organization, all seeking money damages for the climate change impacts and the cost of adapting to the climate change that is coming, building seawalls and so forth. The big issue, all these cases are still pending in one form or another. The big issue is whether they belong in federal court or state court. The plaintiffs would like to be in state court. The defendants want to be in federal court. We have several court of appeals decisions saying that they belong in state court. There's a cert petition in one, a cert petition is expected in another. So we will then see if the Supreme Court takes one or more of these cases. If they do, I think it'll be on hold for a while. If they don't, then this litigation will proceed in state court. The litigation will face, a lot of the litigation is based on a series of studies that have looked at the history of fossil fuel extraction and what various companies and their predecessors did in terms of the quantity of coal and oil and gas they extracted, and what are the greenhouse gases that are attributable to burning of that coal and oil and gas. And so we see charts of this kind identifying the fossil fuel companies whose products led to more greenhouse gas emissions. There will certainly be litigation about whether this action, which was for the most part legal and sometimes legally mandated, was unreasonable under the public nuisance doctrine. There will be litigation about the supply chains, that where on the chain of supply should liability attach. So all of these issues are ahead of us. Not one of these cases has gotten to discovery. So if they do survive the legal motion practice, there are going to be a whole lot of factual issues. The final kind of litigation that I'd like to mention is securities fraud lawsuits. There have been a number of lawsuits brought. Exxon is the favorite defendant in these. One of them went to trial, and there was a trial verdict for Exxon. The New York State Attorney General said that Exxon had been guilty of violating the New York State securities law, the Martin Act. The court held that they had not made out that case. There is a pending case in Texas, Ramirez versus ExxonMobil, which has survived a motion to dismiss. There is a pending motion for class certification. There's currently a dispute about whether a hearing is necessary, an evidentiary hearing is necessary on that class certification motion. Exxon has also moved for reconsideration of the motion to dismiss based on the trial verdict in the New York case. There have been a couple of ERISA class actions that have been brought, all of which have failed. There is some class action litigation pending in California growing out of the California wildfires of a couple of years ago and relating to the PG&E bankruptcy. The only other real climate change class action has been a case in New Orleans against the Army Corps of Engineers for the way it managed a canal that worsened Hurricane Katrina, but that was ultimately dismissed as well. So there has only been a limited amount of class action activity in the climate change arena, and it's going to be very interesting to see what happens in all of these state common law nuisance cases that I've talked about. There's a big flurry of them, and if they survive, I think it'll lead to a whole lot more cases. So that's it for my quick summary of the landscape of U.S. climate litigation.
Thanks, Mike. As previewed, I'm excited to tell you a little bit about the youth climate movement, and hopefully you're seeing my slides now. Great.
Yeah.
So the bucket of cases that you just heard about focus generally on damages. There are plaintiffs that have suffered a unique injury related to climate change, and they're pursuing damages against the wrongdoers. But there's an entirely different type of climate litigation that has been driven by the youth climate movement. In those cases, the plaintiffs are arguing that their constitutional rights have been violated, and they are seeking declaratory or injunctive relief against the government. The leading case to pursue what was a novel theory back when it was brought in 2015 is Juliana, also known as Youth v. Gov or the Kids Climate Suit. In Juliana, 21 children allege that the government is violating their rights under the Fifth Amendment because it has been on notice about the dangers of climate change for more than 50 years. And not only has it failed to protect them from those dangers, but it's actually taken an active role in perpetuating the climate crisis. They are pursuing a declaration setting forth their rights and the government's corresponding responsibilities, and they've asked for injunctive relief in the form of a remedial plan to combat climate change that would be enforced and monitored by the district court. Since Juliana was filed, so many analysts have said that it's too ambitious. But Judge Aiken, the judge presiding over the case, said otherwise. In fact, in both of her opinions on dispositive motions, she said, and I quote, "To hold otherwise would be to say that the Constitution affords no protection against a government's knowing decision to poison the air its citizens breathe or the waters its citizens drink." And with that, she said that the youth plaintiffs deserve their day in court. However, in January of this year, a divided Ninth Circuit panel reluctantly concluded that the plaintiffs failed to establish redressability. They said that it was just too much for an Article III court to order, supervise, and implement the requested remedial plan, reasoning that it really needs to be left to the discretion of the executive and legislative branches. Judge Stanton, who was sitting by designation on that panel, wrote a passionate dissent that again really puts into perspective how high the stakes are here, similar to the quote I just read you by Judge Aiken. In the opening lines of her dissent, she said, "It is as if an asteroid were barreling toward Earth and the government decided to shut down our only defenses. Seeking to quash this suit, the government bluntly insists that it has the absolute and unreviewable power to destroy the nation." It's important to note Juliana is not over. The plaintiffs have filed for en banc review, and I think that their petition has a real shot, considering that the panel said more than once they were reluctant to dismiss the case, and the dissent is very persuasive. But the question remains, if this is the end of the road for Juliana, what does that mean for youth plaintiffs in the US going forward? And I would argue that Juliana sets forth a very clear roadmap. The youth plaintiffs going forward can take what worked in Juliana to refine their legal theories and press on. And in fact, the team behind Juliana is prosecuting similar cases at the state level all over the country. Similarly, there are cases all over the world against governments in other countries pursuing a constitutional law or human rights theory. And finally, there are cases before human rights bodies. For example, there's a case that is a groundbreaking complaint before the United Nations Committee on the Rights of the Child that my firm is actively involved in. When looking at the global landscape, one thing is clear. These kids are brave, they're inspiring, and they're going to do whatever they can to see some sort of action regarding the climate crisis. So that brings us to the separation of powers question. And it's so interesting, the results that we got, it's definitely not what we expected. And I saw someone in the chat say that we should have added a third option, it depends. And I was thinking that too, although then I think most people probably would have taken the option to say it depends. But there's another way to think about this. And that's that the real question isn't an either or, but it's where the executive and legislative branches are failing to take action. Is it the right and the responsibility of the courts to step in to protect the American people? And before we fully dive into the separation of powers analysis, it's important to establish that we're having the same conversation. The first thing is climate change is real. And certainly we have international scientific consensus that it is, that it is an imminent threat to our very ability to survive. And we know that we've reached a tipping point where if we don't take action soon, the threat will be irreversible. That brings us to the different branches of government, starting with the legislative branch. One would think that when faced with this serious public health threat, the legislative branch would take action, but it hasn't. Alternatively, you would think that the executive branch, facing possibly the greatest national security crisis we've ever seen, would take action to protect us, but it hasn't. So where does that leave us? It leaves us with a crisis of unprecedented magnitude and two branches of government that have failed to create any meaningful change to stop it from happening. So in that context, the question becomes, if the legislative and executive branch's failures result in a violation of our constitutional rights, isn't that the exact time that we rely on our courts to step in and protect us? We also can't talk about the youth climate movement and separation of powers without recognizing kids can't vote. They are the ones set to inherit our planet, and they are trying to make a difference in the world. And they're being told, get out of court, go raise your issues to the electorate. Ask yourself, on an intuitive level, does that really make sense? I have to say, thinking about myself as a 13-year-old, I can assure you that argument would not have gone over well. I know I'm not the only one that has Hamilton stuck in my head over and over again. And whenever I get to the line, history has its eyes on you, I can't help but think about the climate crisis. And funny enough, the Juliana plaintiffs in their petition for rehearing en banc also thought of Alexander Hamilton, quoting him. The job of the judge is to enforce the supreme and enduring law of the Constitution over the current will of the majority. Judge Aiken expressed similar sentiment in her summary judgment opinion. Courts have an obligation not to overstep the bounds of their jurisdiction, but they have an equally important duty to fulfill their role as a check on any unconstitutional actions of the other branches of government. When we look back on the seminal decisions coming out of our Supreme Court on civil rights matters, they were not always popular at the time. But now looking back on it, we have nearly universal consensus that Brown v. Board, for example, was very important for the Supreme Court to step in where our executive and legislative branches were failing to protect our constitutional rights. I predict that the same is going to be true with climate change. If we don't see courts starting to take action soon, then history will look back on this as a true failure of the judicial branch. I just hope in the future, when eventually that dissent that I read to you from, that was so passionate, when that becomes the majority opinion, because I really think it will, I hope at that point, it's not too late. And on that very ominous note, I'm going to pass it back to you, Brad.
Okay, thanks, Katie. Well, Gabrielle, I think that's going to be a tee up for you. I'm not sure you quite agree with everything she had to say there, and I'll have a couple questions when you finish, but for now, it's all yours.
So thanks, Katie. Thanks, Mike. It's always great to get a tutorial from Mike. Who would think that you could get a 5-minute overview like that? And Katie, such a wonderfully passionate, informed presentation. Really appreciate it. So I'm here to present the voice of the defense bar. I'm not representing ExxonMobil, for instance, but I'm going to be giving you a perspective that's different than Katie's, and that really is coming to grips with what courts can do, and also try to bring us back to class actions and the focus of what we're doing here. Because what we're seeing here is really reminiscent of what we saw with respect to other environmental challenges. Before there was such a thing as a Superfund law, there were cases dealing with pollution of the water, pollution of the soil, and they used the common law. whether it was attempts to use federal common law, but but really it was typically done under federal common law. And there were failings that the courts just couldn't get past, which is that, you know, we all know, or most of us who went to law school, the basics from tort law is you have to show causation, you have to show unreasonable action at the time, where dumping materials and burying them underground was a much better approach than dumping them in the water. So it was perfectly reasonable to create landfills based on what was known at the time. So, and a lot of these climate cases are also trying to exact punishment, whether it's through injunctive relief against private parties or damages. I'm putting aside Juliana, which is not trying to get, you know, this is to get the government to act. But those laws were, you know, based on common law. And what was finally revealed was that the common law could not deal with contamination of the earth that came from the Industrial Revolution. Basically, all of the paint and all the other waste that had been dumped in order to make our cars and everything else. And so what they had to do to deal with the fact that the common law couldn't deal with it is they went to Congress and they created the laws that we see today, the Superfund law, CERCLA, and RCRA. These are laws that deal with our common, with the dumping of waste. And they've been successful in two ways: exacting payment for past action without imposing any causation or having to find fault. Basically, if you touched the stuff, you have to clean it up today. And then exacting laws for how to manage hazardous waste going forward. So that to me is a model for why the common law cannot work. And I suggest to you that we do have statutes on the books as to how the government has been approaching it. And yes, those statutes have shown to be difficult, like the Clean Air Act has been difficult to address greenhouse gases, but it has been amended to do that. And frankly, since the Obama presidency, which moved the current statute forward as more than any other presidency in the past to address climate change, what we've seen is an electorate voting under the Constitution with an electoral college and installing a administration backed by the Senate that has unwound it or attempted to unwind it. And that's based on the electorate. And that's the country, frankly, we're in. So using the court system, I suggest to you, it's very difficult because either you're suing the government to say, take an action, which really is unprecedented and has been thus far found to be inappropriate because this is ultimately a decision of the electorate and of the legislature as to how to manage this issue and to even how to treat it as an issue. And then to the extent that you're using the common law, there are multiple reasons why the common law as it's currently structured is not going to make this an appropriate way to deal with these issues. In part because it's those issues are backwards looking if you're looking for damages. And what was done at the time is being judged by the law today and by views today. So that's a major reason, as well as which court and in what type of procedure should it be judged. Looking at this as a class action, to the extent that these cases are class actions from the defense bar, There is a playbook that has been developed. You can see it in multiple courts. Exxon in particular has filed many of the same defensive pleadings with different captions on them, slightly modified. So it's a known playbook, but their playbook is going to be that if it's class action, that they're going to remove it to federal court and deal with it there. And that they're basically going to be, even if there's a government action, they have called out all the stops, including bringing affirmative lawsuits to whether it's an anti-SLAPP lawsuit or a direct lawsuit, as in was done in Texas, to try to stop the attorney generals from bringing these types of civil investigations. The win in the New York case is going to be very, very important. Yes, there'll be other types of distinctions on it, but the fact that the New York Attorney General brought a claim saying that that Exxon lied in its in the way that it was dealing with climate change over the years and was not able to prove their case, has already been used by Exxon and will be used by other companies too, to demonstrate that claims against the fossil fuel companies are not going to be successful. So I don't want to take up all the time, but I think that there, you can look at the litigation now. You can see the roadmap, which is going to be bring this to federal courts, and federal courts recognize that this is not appropriate for the courts to deal with. This has to be something that the legislature and ultimately the electorate has to deal with.
Thank you very much, Gay. And so let me tee up a couple general questions in response to what we've heard and get the panel's view. The first one, I'll be speaking as an economist. It's the question of what really are the damages associated with climate change. And if you look to Bill Nordhaus's work, he's saying that by 2100, and incidentally, the damages accrue over time because the emissions continue, the environment continues to warm, and the damages increase. But he estimates that if we don't do very much, by 2100, the damages will be 13.6% of GDP. Now, that's a pretty serious number. That's a major recession. But there'll be economic growth between between now and 2100. So it turns out that what it really amounts to, by 2100, the people will be not 270% better off than we are, but only 233% better off than we are. And that then raises the question, what's the big deal? Why do we have to take all these drastic steps now? And the answer would have to be that Mr. Nordhaus is maybe just wrong. But that's the critical question. And Katie sort of was saying, we're at a drastic tipping point. You have to quantify that somehow. And how are the courts or the law going to do that? So that's my first topic for discussion.
So can I jump in and say, I think that Nordhaus's calculations, which were several years old, are wrong. In the first place, they depend on a discount rate that has the effect of greatly downplaying the distant damages. It is downplaying the damages to children. If you have a discount rate, that means that injury suffered in 2100 doesn't amount to much. But more importantly, his studies were done before we had the most recent studies, the IPCC report of 2018 on 1.5 degrees, that the impact of a continuation of greenhouse gas growth at the current rate would be completely catastrophic. We are now on a pathway to between 3 and 4 degrees centigrade. The IPCC showed that at 1.5 degrees, we're in bad shape. We're now at 1 degree, and we are seeing these wildfires, these heat waves, all these other things. In 2100, at a continuation of current trends, we will have literally hundreds of millions of people who will have to move because where they are now living is uninhabitable because it is too hot, or it is underwater, or it is on fire. The amount of disruption will be immense. And so Professor Nordhaus is well respected, but I think that those numbers really no longer apply given what science is now telling us.
Well, just to push back on one question, one issue of that, Mike. First of all, I totally agree with you. It's an empirical question. The hard part of it, and Nordhaus has said this, is how we will adapt. Yes, 200 million people may have to move, but hundreds of millions of people moved from farms to cities over the last 2 centuries. Human beings move and adapt, and that will reduce the damages.
That completely underplays the nature of the adaptation challenge. For instance, in Bangladesh, there are 175 million people. If 100 million of those people need to move, which is what's expected in 2100 with a continuation of current trends, where are 100 million people going to go from Bangladesh? The history in South Asia is not such that they're going to be accepted in with open arms in India, which is going to be solving its own problem. The adaptation that is going to be necessary, even in the US, there are now 13 million people under one estimate who will have to move. Another estimate is 40 million people by the end of the century. Where are they going to go? Where is that land going to go? What are going to be the damages that they suffer? I think that the notion that adaptation will get us out of this worked if we were only going to have maybe 1.5 degree of warming. Even then it's doubtful given what's happening now. We are definitely on a pathway for much more warming than that. And what we have seen in the past year is a tremendous acceleration, much faster than people had anticipated, of the heat waves and the wildfires, which are rendering even parts of California very dangerous. So I think, with all due respect, you're really understating the challenge that we're facing with unabated climate change.
Well, let me turn this over to Katie and Gay. You and I, Mike, have been having what I think is the right debate. You've really got to try to figure out what the damages are here. But are the courts at all, Katie and Gay, should they be in this game, or is this just too big and too controversial a problem? And let me just throw one more thing into it. The biggest emitter of greenhouse gases right now is China. Are we going to recover damages from the Chinese, and through what venue? It's open season for you two. Gay, looks like you want to go.
I think both Katie and I always want to jump in.
Go ahead, Gay.
Sure. So, you know, those are really good points, and particularly the fact that this is a international, a global. This is, you know, climate change is based on global warming. This is a global problem, and we're not going to be able to put any portion of the United States, much less the whole country, in a bubble to try to deal with this issue, which is, again, you know, the response to that is, well, that doesn't mean, you know, you avoid doing anything. I just would like to come back to whether bringing an action as a class, as a mass, as a group of plaintiffs is the right mechanism based on the laws that we currently have on the books. And I just don't see it, because if you're bringing a nuisance action as a class, for instance, or you lied to me in your advertising action as a class, that it is going to be very difficult to prove that those actions have, you know, whether it's the statements you made in advertising or the way that you conducted business over years under laws that promoted fossil fuel. Fossil fuel was inherent to the United States becoming the economic powerhouse that it became. Was that doing something wrong that people should be punished for and found liable, which is what the nuisance laws are about, which is a very different issue than what Katie was dealing with, which is, okay, maybe you don't say that you did something wrong. The law can also deal with strict liability, but the law has to set up a construct for dealing with it, and the current construct doesn't work. Katie.
Thanks. Yeah, well, so first, and this goes back to my PowerPoint earlier, but I think the executive and legislative branches should be dealing with climate change. I think we should be dealing with it in a coordinated global way. And, you know, so many other people feel the same way as well, which is why we're seeing these types of cases all over the world. But, and it's funny, I have a different perspective on the class cases than you gave. I actually think we get closer to agreement there. And that's the question I ask myself as a plaintiff's lawyer, which is what value would it add to bring these cases as class cases? So for the big oil cases, for example, they are generally brought by a state AG in their power of parens patriae, meaning that it's on behalf of the residents. And similar, you might have a city or a municipality bringing suit to recover the costs of rising sea levels or other damages related to climate change. And if they don't recover those costs from the wrongdoers, then they will be shifted to the taxpayers. So any way you cut it, for those types of cases, it's going to have widespread impact of all of the residents of those jurisdictions. So in a sense, you achieve the same efficiencies that we're looking to achieve in a class action, just without all the fun that we normally get to have at the class certification phase. And then for the youth climate movement cases, there's a question of whether it's really necessary in the context of declaratory and injunctive relief. You can get the same relief with a single plaintiff, a group of youth plaintiffs, as you can with a class of 1,000 youth plaintiffs. So what would it really be adding to bring those cases as a class? On the other hand, because these cases tend to be high profile and they're also litigated in the court of public opinion, I can see an argument that it adds weight to just say, we're gonna have a B2 class to show how widespread this issue is. And then the last thing I'll say is that climate change is evolving every day. This gets back to some of what Mike was saying earlier. And we don't know how much worse it's going to get, and we don't know how soon it's going to get worse. We do know these extreme weather events are happening more and more, and you can always make the argument that they were caused or exacerbated by climate change. In the future, we have no idea how, you know, cities and insurance companies and corporations are going to react in the face of really unprecedented extreme weather events. In that sense, the climate change litigation umbrella might get larger, and we might see more and more cases similar to that Katrina case that was talked about earlier coming down the stream in the future. But there's just no way to know at this point because we don't know how fast the intensity and frequency of these extreme weather events are going to increase.
So I disagree with only one little bit of what Katie said. I think we have an idea that these extreme events are going to get a whole lot worse, and there's increasing quantification of that it will get worse. But let me just address two things very quickly. I think everybody agrees that ideally Congress would act. Congress has not passed a major new environmental law in 30 years, since 1990. Congress has been completely paralyzed by partisan division. So in the absence of congressional action, it's not surprising that people are resorting to the courts. And that's not only in the US, as we've seen, it's happened all over the world. So ideally Congress would act. Who knows whether after the election, whether that'll change. Let me just also address the China point, because of course that comes up a lot. The US was for a long time the largest emitter of greenhouse gases in the world. It was surpassed by China about 15 years ago. We're now the second largest emitter, but we're still responsible for more of the load of greenhouse gases in the atmosphere than any other country, because the stuff stays up there for more than a century. So it's basically cumulative. The US refused to ratify the Kyoto Protocol in 1997 because it didn't impose emission reduction commitments on China and India. But part of the theory is that our inaction might drive others to act, but it has had the opposite effect. It has had the effect, the US inaction has had the effect of giving other countries an excuse not to act. If the US, historically the biggest emitter and the richest emitter isn't acting, why should we, our developing countries with much lower per capita incomes? All the projections about how the climate problem could be solved rest on the US taking strong action, and China and India and Europe and every place else. We're all in this together. But it is no excuse not to act that others aren't acting. We all have to act, but if even reducing our emissions is one very essential piece of the puzzle.
I think we've got a lot of really interesting things teed up. And at this point, Jeff, can we see if the audience has any questions or any thoughts that they'd like to put to us or express?
We do have a couple in the chat. One of the questions is, well, okay, I understand that it would be better coming from the electorate and having the legislature do that, but why wasn't there a similar response in the opioid litigation? I mean, opioids have been issue has been successfully, or is on the way to being successfully addressed, at least on some level, maybe not enough, but on some level in the opioid litigation. Why throw up your hands at climate change if it works in the opioid context? And so since I've read the question, I'll start a response. And I just say that opioids are very different from a legal standpoint, even looking at this issue, and as well as looking at the executive response. There has been executive response to the problems with opioid addiction. It's been something that's a legislative response, in part, including because it costs the executive a lot of money, the federal government a lot of money. And also it is, you don't have the same causation problems. It's not like opioids have been at the level that has, caused the level of addiction that's been going on for years, and there's a direct cause and effect. And the supply chain is a lot easier to target. So I think that the ability to prove causation is a lot easier. And there are existing constructs to deal with food and drugs that are misused, that are prescribed for purposes that are legal. I just don't think that we have the same series of laws to deal with climate and greenhouse gases that we have to deal with pharmaceuticals.
We got another question here. Let me go to this one. And it relates really to the discussion that Mike and I were having over the damage function. When I teach my course on energy, climate change, and finance, which is primarily to MBAs and engineering type students, there's a big dispute even amongst them. And the question is right along those lines. It says, should the question of whether courts should delve into the political thicket on climate change await more certainty on scientific opinion regarding the causes, not really so much the causes of climate change, that's what the question says. I think we all know what causes it, but what the impacts are going to be, what the costs are going to be. So that's the question.
So my answer to that is no. Every scientific society in the world has declared that climate change is mostly caused by human activity and is having terrible consequences. The scientific bodies at the international level convened by the UN, the Intergovernmental Panel on Climate Change, and the World Meteorological Organization also agree. The peer-reviewed scientific literature resoundingly shows the terrible impacts that climate change will have. The only doubt you see expressed is on Fox News and Rush Limbaugh and the editorial page of the Wall Street Journal. It is not in scientific publications. There is obviously a dispute about just the pace of impact, and a lot of legitimate dispute about the appropriate policy response. But as you say, causation is not in any serious doubt. And the only question is, will it be this bad or will it be this bad? Yeah, how bad is it going to get? But even under the best case scenarios, the reasonable best case scenarios, it's going to be a whole lot worse. And so scientific uncertainty does not justify inaction. It does not justify going slowly.
Yeah, I agree with all of that. And I'll just add that because there's international scientific consensus, it's really dangerous to suggest otherwise, because this should not be a partisan issue. It's a global threat, and it's a threat to the American people. So this should be an issue where everybody wants to take action immediately. And anytime I see something that's questioning the science, it just really gives me pause, because the climate denialism is so dangerous on a macro level. And that is probably why we're seeing that the legislative and executive branches have not acted when they really should have.
Next question we have here, and it's related. It says, any comments on the recent climate action filed by the city of Charleston against big oil? Separately, is state or federal court better for the plaintiffs? That would be mostly, I think, to Katie and Gay, but maybe to Mike as well. Katie, you want to start?
Sure. I'll take the second part of the question. And I think generally we see that state court is better for plaintiffs, especially in these big oil cases, because there's a strong claim under state law, and you can avoid any tricky preemption issues that you would see under federal law. And it's also helpful on this separation of powers issue that we've been discussing today. Right.
On the other hand, Katie, if you win in Juliana, federal court's the best place in the world to be.
Hopefully, we can hope, right?
Right. So it's generally perceived by the defense bar that, I mean, all of the maneuvering has been to get into federal court one way or another. There's been success in federal court of having this seen as a political question, or basically non-justiciable by the courts, that it's up to the legislature. And the same thing, the same playbook. I mean, you can pull out the pleadings from Mike's fabulous compendium of cases that have already been filed, and those same pleadings are going to be filed in Charleston. I don't know, Mike, did you see anything particular about the Charleston case that makes it unique from any of the other cases that have been filed so far?
No. We're seeing the emergence of it in addition to the state common law nuisance theories, more theories about consumer fraud,
Right.
and those have not yet been really litigated, but they're beginning to pop up in some of these cases.
Right. And the defense bar, in response to the consumer law, is basically saying these, among other things, are saying that this is really a federal question. This is just a guise for the trying to get this under some hook to keep it in state court. There's also been part of what the defense bar has done is said that these are really, the consumer law cases are really class actions, should be treated as such, and should be brought into the federal courts under the Class Action Fairness Act. So there's, again, the pleadings have already been filed in other cases there. I'd just like to suggest to folks that to the extent that we look at what's going on in Europe in particular, that there's been a different response in the courts there. And why has that been? And I largely think that why that's been different in Europe is because they have a different legal structure. They often have laws on the books that recognize as a matter of law certain rights to the environment or certain human rights, and that can be used more effectively as legal hooks to bring action, to have as an action forcing mechanism. you know, I'm not saying that Europe is going to be able to solve it all, but to look at the question of why the courts aren't effective, I think it's helpful to look at where has there been successful claims on some level to move things forward. I think that that's happened more in those jurisdictions where there are laws on the books that recognize human rights, environmental rights, the right to a clean environment as a precise legal right, not as an inferred right.
Yeah, the strongest decision we've seen in the world is the decision from the Supreme Court of the Netherlands in a case called Urgenda, in which the court directed the Dutch government to reduce the country's greenhouse gas emissions even lower than the Paris commitment of the Dutch government. And that was based on the European Convention on Human Rights, which is embedded in the Dutch Constitution. And so it was that was the legal basis for that very, very strong decision. In the Juliana case, of course, there was an effort to establish a U.S. constitutional right to a clean environment. And interestingly, the majority in the Juliana case that dismissed the case expressed some interest in that constitutional theory, but they ruled, as Katie said, that it wasn't justiciable, that it wasn't appropriate for the federal courts to be making those kinds of decisions.
Yeah, it's really interesting because they definitely seem to be they wanted to rule for the plaintiffs. And I think they just got held up on the remedial plan that was proposed, but you didn't see them saying the same thing about the declaratory relief that the plaintiffs were seeking. That's why I said, I think Juliana really provides the roadmap to push these cases forward in the future. And when thinking about it in the international human rights context, you want the United States to be the leader. A lot of people say Juliana inspired a lot of that litigation around the world. And it is really sad to think that we're at a moment where countries all around the world will be taking action because they have a constitutional right. And here in the United States of America, we're saying that our fundamental right to life doesn't quite go that far.
You know, incidentally, it's interesting that Chairman Xi yesterday said that China now has a plan to be carbon neutral. I don't know exactly how he's defining that, but by 2060. But I think he's taking advantage of our inaction and our legislative and executive failure to move to see if China can play a bigger role in the world stage with regard to climate change. I don't know if any of you have any thoughts about that, but I found that very interesting that he decided to make that statement yesterday.
I agree with that. I'd love to see the plan for getting there. It was certainly a bold, ambitious plan that got a lot of attention, but we'll see how it gets there. Can I ask Katie a question? Does your view about the future of the Juliana case or these other kinds of cases, does what's happening with the composition of the Supreme Court give you any pause?
Yeah. Doesn't it give us all pause? It's terrifying. I hope we don't descend into the Handmaid's Tale. You know, that's where I go when I think about it. It's very, very scary right now. But I still think in terms of when you look at it, like the moral arc of the universe is long, but it bends towards justice. In the long term, no matter what Supreme Court we have, the right decision is to take action on climate change. So the only question for me is it going to be within my lifetime? Is it going to be in my kid's lifetime? And is it going to be too late?
And is it going to be coming out of the courts? And that's, you know.
That would be great if it didn't have to come out of the courts. If there was no issue, because that gets back to how I was framing the question originally. If the executive and legislative branches took action, then there wouldn't be a violation of our constitutional rights because they would be protecting us. So it all kind of comes full circle.
This is one of the many ways in which the stakes of the November election cannot be overstated.
Well, I think, well, go ahead, Katie. I was just going to say our time was near.
No, I agree. Fully agree. Please vote. All right, the youth plaintiffs cannot vote for them.
I think it's been a wonderful session. Let me sum it up with one comment from Richard Feynman that I always like, which is that nature does not negotiate. Her laws are absolute, and we learn to live within them or we bear the consequences. So thanks so much, everybody, for joining the panel. We hope you, the audience, enjoyed it. and look forward to meeting you in person when we move beyond this virus a little bit. Thanks so much. Bye-bye.
Thanks so much.
Thank you.
Well, Brad, Katie, Mike, and Gabe, thank you for that discussion about climate change. This is such an important issue. It was a great topic to conclude our 3-day conference. Now, I'd like to turn it over to Robin Cantor at BRG for some closing remarks. All right, well, while we're waiting for Robin to join us, this conference was recorded, and our colleague, Colin Post from the Beer Group, will email Zoom links with a password to access the recording. And I'll turn it over to Robin. Robin, you're on mute.
Yeah, I know. I'm sorry. For some reason, it was like a shutdown of my system here. I'm not really sure what's going on, but it must be the transition. Well, first, let me just say thank you to so many people that worked so hard to pull this session together. And also, I completely appreciate the many challenges that we've had to pull this together. But I want to start by thanking the participants and the organizers, Beard, Colin Post, and Peter Chapman, also Jennifer Fagan for an amazing operation of the Zoom platform here and keeping us all together and able to do this. It was really incredible. I learned so much. And also to thank our sponsors and my co-chairs, Chris Ritchie and Jeff Klenk, and the moderators and all of the faculty. I mean, it was just an amazing experience, and the discussions were wonderful. And I have to say that I am having a hard time deciding which was my favorite. But I did want to, in my closing comments, come back to where we started the conference on Monday, in paying our respect and sharing our loss, the loss of Justice Ginsburg, because to me, that really was such a shock to have happened over the weekend. And I have to say that I was very concerned about how that might eventually affect the conference that we were starting on Monday. And I did take some time to look at some of the things that she had said in her opinions about class actions. And I saw that she actually would bring up two things very often. I think this comes back to our conference here. One, she stressed the issue of class actions and efficiency, and that whatever you were going to be doing about rules, you should be giving some thought to how is this making the class action vehicle more, a superior way to handle the litigation and think about efficiency. But the other thing she would often bring up was being principled, that you have certain things you want to think about with rights and you want to be very principled about that. And I have to say, in the sessions that we had, I saw some of these things coming up over and over again. In our mass arbitration, there certainly was this issue of whether or not we're being principled with the way we are moving forward on this issue of can you have these mass arbitrations? What do the contracts say? Judge Shinlin reminded us to be careful for about what you wish for, and I think that's a very good point here. In the antitrust, we also saw this tension over direct versus indirect plaintiffs and whether or not indirect purchasers, and where should you be placing the litigation so that you have a close match to the damages. And again, that's really subject to your ability to measure things. And I think that gets back to, well, can you be principled? So Justice Ginsburg's opinions really emphasize that you just can't support one perspective versus another perspective, but that you really have to focus on making the mechanism more efficient and capable of not impeding the vindication of legal rights that people expect. And something else she reminded us of, and something that really came through, I think, in the climate change session that we just had, which is if your systems become tone deaf to the unfairness that they may be creating through their decision making and their rule changing, then other systems are going to emerge to respond to this. And that is one thing she reflected on, is she saw a tension, for example, in the mass arbitration between consent and coercion. And she pointed out, we can see these outside systems are actually emerging and trying to respond to this. And I think there's a very important message there in what we've been doing with this class action conference, is we've been trying to balance the viewpoints. My colleague Jeff has mentioned this many times, that when we put together these sessions, we really do focus on making sure that you have both a plaintiff representation and also defense representation. And then every now and then you also have representation of the experts, including economists. So I think that it's very important to keep that in mind. If our systems don't respond to the demands that the users expect, then other systems are likely to emerge and address that problem. And I'm always reminded of the statement in economics that ultimately consumers do vote with their pocketbooks. But I would also like to point out that ultimately voters vote with their votes. And so I think that as we go forward, there's going to be many other issues where we see these conflicts. And I know that that will play into our planning of the conference going forward. So with that, I'll turn it over to Chris. Thank you very much.
Robin, thank you. And thank you in particular for everything that you and Jeff Klenk did to prepare for this conference. And thanks to your colleagues at BRG for their significant contributions to the panels. So to wrap this up, on behalf of Huntington Bank, BRG, and the Beard Group, thank you for joining us. We hope everyone remains safe and healthy, and we look forward to seeing you in person soon.